Hello, everybody. We'll let everybody trickle in for just about 30 seconds, and then we're going to get started. Everybody's still falling in. Okay, so thank you, everybody. Welcome to today's presentation. My name is Abby Mars, and I'm an educational support coach here at Family Matters Parent Training and Information Center. Parent centers are all over the United States. In fact, IDEA says that each state must have at least one parent training and information center. So we are one of the two parent training and information centers that serves the state of Illinois. Our goals are to work with families and families of all ages, families with students of all ages throughout the state, and provide them with more resources and information about what their role is in special education. Please remember that Family Matters Parent Training and Information Center is unable to offer CEUs for training for participants. Certificates of attendance can be requested by contacting the trainer via email. Family Matters is not a legal service agency and cannot provide legal advice or legal representation in any way. Information received from Family Matters is not intended as legal advice, nor should it be used as substitution for legal advice. We are funded under a grant from the U.S. Department of Education. However, the contents that we provide you during this presentation are not necessarily representative of the policies of the U.S. Department of Education, and you should not assume endorsement from the federal government. This webinar is being recorded today, and the recording will be available on the Family Matters website following the presentation. Please use the chat box to state your name and title and organization that you're coming from. All questions should be put in the Q&A box. This will be addressed at the end of the presentation today. We will address those questions that you have for Laura. Please help us by completing that survey after we're finished today, and a copy of the presentation slides were emailed to you yesterday, but I will put them in the chat right now with a link to that Google Drive where you can get a copy of those. Family Matters is first and foremost an educational advocacy helpline. You can call us Monday through Friday, 8 to 4 o'clock p.m. and ask us questions regarding special education or accommodations in the state of Illinois. We will return your phone call. If someone doesn't answer your phone call, we will return that. We hold the state's grant for the educational surrogate parent training portion of their program. So we train individuals across the states to become educational advocates for students within the care of DCFS. We offer once a year our COMPASS program. COMPASS stands for Coaching Others and Mentoring Parents About School Services. This is a 10-week program in which we help you to understand your role in special education advocacy. Our DAISY data collection program actually just ended yesterday. So Carrie did a fantastic job again this year presenting that program on understanding data. That's something that we're hoping to offer at least once a year. And we are toying around with the idea of offering that on a Google Classroom platform. So if you're interested, please email myself or Carrie. We offer several special education advocacy trainings like today, and we invite professionals from across the state to do that with us. We are very fortunate to have blogs from two world-renowned self-advocates, the amazing Bridget Brown and Zoe, and we offer quarterly newsletters and transition news blasts as well as monthly podcasts. That's a picture of me. We don't need to see that. So now I'm going to share the real reason we're here today. Make sure everybody can see my screen correctly. All right. Oh, you know what? I don't know how to present in this thing. I don't know how to make it big. We'll just have to stay here. Okay.
I think you can do like the bottom right. There should be like a little presentation box. But this is fine.
This is fine because I don't know how. I'm not Google savvy enough. I'm working on it. I'm working on it. It's not happening.
And poor Abby has to show the slides because my computer decided it wanted to update today. And so you'll have to just forgive us. We're a little bit of a mess.
A little bit of a mess here.
That's all right. Is that
good? You sure?
Yeah, I think it's fine.
Okay. All right.
If anyone's having trouble seeing, you can put it in the chat box and we'll try to figure it out. But I think you'll be okay because they should be all right. So I'm Laura Hart.
Yeah, go for it. I'm going to mute myself. So
All right, very good. Sorry, I just cut you off. Well, I'm off to a great start, guys. Okay, so my name is Laura Hart. I'm a special education rights manager with the Human Rights Authority, that is a division of the Illinois Guardianship and Advocacy Commission. And the next slide here is, again, a picture of me, but also I wanted to make sure everyone really understood where I was coming from. So my role is to be an advocate. And I am very fortunate that within the program that we have developed here with our agency, that is a support system. So what that means is I'm not making decisions for anyone. My job as an advocate is to make sure that parents understand what all their options are, help walk them through how they might be beneficial to them as a parent, what might work for them as a student, and then ultimately those decisions are made by the parent. I'm not an attorney, and nothing we're going to talk about today is legal advice. I am merely giving you the overview that I give my clients when they call in, people who want to discuss their individual situations. We talk about these options. And then I believe then the next trainings take you a little deeper into those options with some of the folks that do those day in and day out. So that is that. The next slide is our agency. Just a really quick overview. So we are a state agency run by a board of commissioners that are appointed by the governor. We have 4 primary programs. The first one on your slide is Office of State Guardian, and that's the one that most people are familiar with. That's guardians of last resort for adults with disabilities. So if an individual needs a guardian, after age 18, then we are appointed by the courts. We also have legal advocacy services. So that's legal advice and representation for both children and adults with disabilities. They primarily do mental health commitment representation, but we also have a special education attorney, which I'll talk about in just a minute. Our Human Rights Authority is the investigative body. So, in order to investigate complaints through the Human Rights Authority, you just have to have an individual with a disability service provider, and a potential disability law violation. And so, what happened is our Legal Advocacy Service program and our Human Rights Authority program got together, and we were working on training our staff on special education laws because we were getting an influx of special education cases that fell under our act because special education schools are disability service providers. So we started off with training. We realized very quickly that the investigative process through the HRA that is designed to be lengthier, it's designed to make policy and systemic change through their investigations, wasn't fast enough for students who need resolution quickly. And so with that was the 4th area was developed. So the special education collaboration of the HRA and the LAS. So a little bit about what the special education collaboration does. Our mission is to navigate special education through training, advocacy, and legal support. So we offer those 3 areas. Training and information looks exactly like it looks right now, or it can be a phone call or an email, any way that I can help a parent or a community provider sort of figure out, what laws they need or where they can get more information or give them the tools that they need to go out and be advocates on their own. Special education advocacy is a more formal process. We have intakes, we assign advocates across the state based on a multitude of criteria, regionally specialized, things like that. And then lastly, we offer legal support. So we do have support for mediation and due process as far as your procedural safeguards would go. The next slide kind of goes over, I think if you would have said to me many, many, many moons ago when I was a college student that I was going to be using the law in any capacity, I probably would have laughed. Like I thought of my role as a helper as, social work, sociology, psychology, doing things from that perspective. And I think it's super important now that this program has started and has grown, that people really understand that when I am telling them that something is supposed to happen a specific way, or if I say the next step is to request, such and such, that those all stem from special education laws. There is a federal law called the Individuals with Disabilities Education Act. Most commonly, you will hear IDEA, although you will see that there has been some reauthorizations over the years. So sometimes it's labeled as the Education for All Handicapped Children. You'll see some things that happen under various, as we grow and we make adjustments to our system, there's other things that are there. But basically, that law ensures that students with disabilities are provided a free and appropriate public education that's tailored to their individual needs. And this is the primary law for special education. And I threw the link up there that can take you straight to that law. So if you were to call me and say, what's going on with this and this, I am most likely going to send you the similar link and say, here is the law that we can reference or you can use in a meeting, things like that. We also touch a little bit on the Rehabilitation Act. So when students are said to have a 504 plan, that is all based on the Rehabilitation Act. It's actually a civil rights statute, and it really covers anyone with a disability who has some kind of impact to major life activities. So while IDEA may have narrower criteria, that's the law that outlines IEPs. 504 is kind of broad, and it's really about reasonable accommodations for anyone who might need that. So that's the difference in the two federal laws. And then also Illinois has narrower laws for special education under Title 23 for education school code. You'll hear people say school code. And then also Section 226 is special education. So those are the main laws that I pull information from. You could potentially find the answer to all the questions in those laws, although not always easy to navigate and somewhat overwhelming. So that's why I'm here. So the next page you're going to is titled Procedural Safeguards. So this is a fancy word, in my opinion, to say rights. So your procedural safeguards are your rights. It is what the law says you can do when you disagree with the district. And it tells you what your time frame should be, what kind of notices. Almost everything I'm going to talk about today can be found in procedural safeguards. Parents are supposed to get copies of procedural safeguards at the IEP meetings. A lot of times when we're working with older kids, I hear school districts ask parents, they'll say, hey, did you get it? Do you want another copy of your procedural safeguards? And parents are like, no. And I get that. I remember when HIPAA was new. Sorry, that ages me significantly, but I remember when HIPAA came out, and I remembered that, when we first started going to the doctor's office and we were talking about that confidentiality law within a medical setting, people wanted to go through the paperwork with you and go down and break it down for you. And then over time, now they just offer it. They say, do you need another copy of your HIPAA? And you sign off, and you may not have access to that from the original IEP meeting that could have been 10, 15 years ago at this point. So I also wanted to make sure you had access to the ISB form that goes over all procedural safeguards. So again, you should get those at the beginning of the meeting. If you got a paper copy or an electronic copy and you have it saved, that's wonderful. And if not, there's one that is from the Board of Education, not necessarily your school districts, but your school district should follow that pretty closely. So it does a good job of outlining it. Also at the bottom of this slide and several of the other slides, in the bottom corner, you're going to see numbers and letters that correlates back to the law where that is. So if you don't need this information for years and you're coming back and you're pulling out the slides and you're wondering, okay, well, she said this, but what does that mean? You can pull up those laws specifically and see what they say. So when you're going through, if you were to pull up the procedural safeguards, which we're not going to do because many of you already have those, that could be a whole like procedural safeguards, when to use them and all that is a big piece of what we're doing today, but we're not diving deep into each one. So I want to make sure you guys get a generalized overview of what those rights are. So the next thing that we need to talk about is prior written notice. And this is, to me, the crux of a lot of the advocacy that we provide. Put it in writing. So that's what we're asking a school district to do anytime they're changing the provisions of FAPE, so that free and appropriate public education. So anytime they're making a change to an IEP, whether that's accepting a change or denying a change, or any kind of edit to that FAPE, then parents have the right to receive notification of that through prior written notice. So anytime we're proposing a change or refusing a change, and there's the law in the bottom corner again for that there. So the next slide goes into what that should be. So we're not talking, when I say I want prior written notice, I don't just mean I want it in writing. I mean, yes, that's the gist of it, of what I'm saying. I want it in writing, but I don't just want them to say no. I want an email that says, no, we're not going to do this, or an email that says, yes, we're going to do this. Meeting notes sometimes have that information in there, and they're like, the team disagreed. What prior written notice is a notice that includes all of these things specifically. So I will tell you right now that in Illinois, the IEP document copy that you get, so at the very end of an IEP meeting, a school district should be providing you a copy of the IEP. You should have additional notes, all the changes, things like that in there. If that IEP contains each of these bullet points, that can be considered prior notice in Illinois. The problem is that very frequently it does not have all of these pieces in it, and parents don't know that they can ask for those pieces. So the popular question is always, does that count as prior written notice? It does if it has all of these pieces. If it doesn't, then we would like them to either edit it to include all of these pieces or write it in a separate document. Some states require like a cover page that goes over each of these things in paragraph form, and that be put on top of the IEP anytime changes are made. But that is not something Illinois requires. Some school districts still do it depending on where you live and what kind of complicated nature the IEP is. You're more likely to see a cover page that summarizes some of that in a more complicated, lengthy IEP, so that you can quick pull it up and see it. So some school districts do that. Otherwise, the IEP does count for that. So I want to real quick run through what that means. So there must be a description of the action proposed or refused by the agency. So in Illinois, the agency is your school district. So they have to put into prior written notice what is being asked, what is being refused. So we're saying, yes, we're going to increase speech minutes, or we're saying, no, we're not going to provide a one-on-one aid. And then the next bullet is why. Why are we not doing that? And the why has to include evaluations, data pieces, like things that have been tried previously. All of that information that was used to make that decision needs to be in there as well. It also has to include a statement that the parents of a child with a disability have protection under the procedural safeguards. And so that's that checkbox that most of you see when you look at an IEP on the first couple pages. When they're signing in for attendance, they'll ask you if you want a copy of your, procedural safeguards, and you mark that box, ensuring that you have gotten those. So if you need them, that's your time to ask for them. Another thing I see with that is we often see that when the school district emails a final copy of the IEP after the meeting to the parents, if they're doing that electronically, you might notice that prior written notice can be a link in the signature or a link in the email letting you know where you can have access to that. And all of those count as far as them providing you with your procedural safeguards as part of prior written notice. It also has to include sources for parents to contact to obtain assistance in understanding the provisions of this, a description of other options that the IEP team considered and reasons why those options were rejected, and a description of any other factors that are relevant in the agency's proposal or refusal. So we're not looking for a yes or no. We're looking for a why, a what was tried. Whenever we're talking about prior written notice in trainings, the best example that I can give is, disability accommodations under ADA. So so let's say a parent makes a request, they want an elevator installed into the school building for their student who uses a wheelchair. The school district then could put in prior written notice that the expense of an elevator is not possible, or that the building structure doesn't allow for that. But these are the other things that they have considered and offered, and they can choose something that is less expensive, less time consuming, as long as it addresses the concerns and we're putting in writing why that was the chosen outcome. So it's super key in advocacy to really ask for that prior written notice, to check the IEP when you get them, to know what it says. Very often parents are calling me and asking questions, and I'm like, well, it depends on what they said in writing. Why did they deny it? And why something is approved and denied often drives the next set of procedural safeguards that we're able to offer parents. Like if they put in writing that they just, school district doesn't want to spend the money on an aid or an elevator or things like that, then we know that that could potentially, result in legal services, because free and appropriate public education can't really be putting the burden more on students with disability than not. So it really depends on what they put in writing, and having that and talking through that with someone can help you process a little bit, and determine what your next steps are. So prior written notice is first. Anytime, any dispute, any decision, anything at all, get your prior written notice, make sure you have that and that it's clear and it makes sense first. Before going on too much into what some of the other procedural safeguards are, I want to talk about, in your procedural safeguards, it will talk about parental consent. And so on the next slide, it talks about when you have to give parental consent. And I want to make sure everyone understands this, because it's a huge misconception based on what we think should happen. So the law says that parental consent happens for evaluations, so initial evaluations, reevaluations, anytime testing is being done on an evaluation front. So not your data collection, not every day, not, classroom testing, not progress monitoring, but actual evaluations are done. There has to be fully informed consent provided for those evaluations. So your very first meeting, when you go in for a domain meeting, and anytime you go in after that requesting evaluations, or if they're requesting evaluations, a parent will sign consent. The other time a parent signs consent is after the student is determined to be eligible for special education. Parents have to sign consent for special education. That consent doesn't mean you agree to eligibility categories. It doesn't mean that you agree with the IEP. Very often, parents are signing consent before the IEP is even developed. So the order of things is not something we're really reviewing today, but it might help and make sense a little more when we're talking about parental consent. So the initial request for evaluation requires a parent's consent just to evaluate. Then an eligibility meeting is held, and at the end of eligibility, if the team agrees and the parent agrees and the student is eligible for special education, then a consent to receive special education is signed. Outside of those signatures that you're providing, you may also sign for attendance. You may also sign waivers. So they're supposed to give parents 10-day notice before they have a meeting, 10-day notice before they implement anything. And a parent may choose to sign a waiver to like waive that implementation time so it can start tomorrow or Monday or however that looks. They also might do waivers for attendance for IEP members, so a parent might sign then. Other than that, there are no consents necessary. There's no signature to say, I like this plan or I don't like this plan, that I agree with this minutes or I disagree with those minutes. In Illinois, we interpret that parental consent to mean that the IEP team as a whole, so that includes the parents, but the team as a whole makes decisions on what goes into that IEP. So while a parent can revoke that consent at any time, so in the middle of an evaluation, you can stop. In the, if it's you had an IEP, you put an IEP in place and you don't want the student to get any of those services again, you can revoke the consent for special ed and the IEP isn't in place any longer. If you ever find yourself in that position, I suggest reaching out to somebody and talking through it, because there are times, many times in recent years, where we have seen that revocation of consent sort of used in inappropriate ways, where it is offered for a parent to revoke consent in order to get certain things, and that's not okay. We've seen situations where parents think that if they revoke consent, that it will just pause the IEP until they sign it again. And that really isn't the case. It starts the process over in theory. Sometimes we're able to work things out, but it's not as simple as just revoking consent. It's an all or nothing package deal, because the team decided that this is what's appropriate. Again, team including parent, so that consent is for all special ed or no special ed. It's not to say, well, I'm just revoking consent for speech, or I'm just revoking consent for, math interventions. It's all of it. And so before making that big of a decision, we want to make sure you understand what all that looks like. So give, Abby a call or our program a call, or someone who can kind of walk you through that a little bit further. So that's your parental consent. The next right you have is the right to participate in meetings. And so the law very clearly outlines who has to be in an IEP meeting for it to count as an IEP meeting. And if someone is going to be absent, then parents will have to excuse them. That's one of those times when you'll sign a signature. But the parent is one of the key members of the team. So is the school district decision maker, a special education teacher, a general education teacher, any service providers, any evaluators, if you're at a meeting where they did evaluations. Like, all of those people are part of an IEP team, and the parents are part of that team. And that is one of the benefits and also the challenges of the setup we have here in Illinois, where you're consenting to all special education. So it's possible to be in a meeting and participating, and in the end, you have a difference in opinion from your school districts about how something should be done, whether that's more services or less services or provided a different way. And so you are there as an active participant in that meeting. They need to set it up at a time and a date and a place that is convenient for a parent. And really, excuse me. And really, ultimately, they need to make sure that they've made every effort. The law is very clear about school districts using a variety of methods to reach parents, to include them in the IEP meeting, and setting up times and rescheduling when it's convenient and things like that. So they should be doing everything to make sure that a parent gets to the meeting, and then also that they are part of that team. But in the end, there's always going to be differences of opinion. And so we're going to kind of go in a little more to that here in just a second. I have one more slide before we really dive deep into dispute resolution. I just want to mention quickly, when you're looking at that procedural safeguard form that your district gave you, or if you click the link that I provided to you earlier, you will also see a lot of information about evaluation and discipline. Those are also on there. I'm not going to dig super deep into those, but if you have questions about evaluation, whether that be an initial evaluation, a reevaluation, or independent evaluation from an outside provider, you can find more information on your procedural safeguards about that, as well as discipline definitions, suspensions, and manifestation determination reviews if you find yourself in a position for that. So if you are looking for more information on those are also located within the procedural safeguards. But we're not going to jump down those rabbit holes today because those are absolutely entire trainings all on their own. So we got to the point in a meeting where we're going to look at our dispute resolution options. So there's a couple things. I'm going to set up what I think is a typical scenario based on what we see. So I see situations where we're in a meeting and in this case, we're going to say that all the policies and procedures were followed. The school district has done all the steps. The parent has done all the steps. We have all the data that we need, and we are at an impasse. We cannot agree. It is okay at that point to just let that meeting be done and then review your dispute resolution options. So those options could be, you could request another IEP meeting. Maybe things were getting too heated. Maybe you're missing a key player. We've had that happen plenty of times where, we get into an IEP meeting and someone we excused, we realize is a very key person to the process, or maybe we have a special education teacher there, but it's not the special education teacher for the class that we're having an issue in. So we can have another meeting. Meeting requests can come from anyone. The district is obligated to respond to those requests by either putting in writing why they're not going to have another meeting, or to schedule that meeting. The next option is state-sponsored mediation, meeting facilitation. Then we have state complaints, mediation, and due process. So then these next slides we're jumping in are going to explain each of those things in a little more detail. This is how I would present it to you. So you are a parent and you have come to an impasse. They have put it in writing in the prior written notice. So we're going to assume that we have prior written notice and that we just disagree about something in the IEP implementation, something about the provision of FAPE we don't agree with. So the first slide is requesting an IEP meeting. So anyone can request it. The district has 10 calendar days. I write that up there specifically because for some reason, special education law bounces around. Some timelines are school days. Some timelines are calendar days. Some things are, business days when we're talking about certain records. So in this case, it's 10 calendar days to respond, not to hold the meeting, not to have it all resolved, but 10 days to respond to the request. If they disagree with the need for an IEP meeting, they have to put that in writing. It specifically says in the law they have to do that. And if they agree to the meeting, then one would be scheduled. So that's what the law states. The law is up there again for you to reference back to that if you need it. I have a small caveat to this at the bottom. So requesting a meeting should always be your first line of defense. You should always try to work with your team. It's what makes resolution happen the fastest, is to bring everyone to the table, discuss concerns in a healthy environment, and be able to implement that in a quick manner. And so if you have the IEP meeting and then the dispute still exists, you can extend the meeting, reschedule the meeting, or move on to other procedural safeguards. But all you have to do in that meeting is just agree to disagree. I tell parents all the time, I said, just When you feel like you can't come to an agreement, tell them to please document your disagreement, that you disagree with whatever the decision might be, and then the meeting can end. There is nothing that says that that has to be fixed that day. So if you need more time, if everyone's agreeable to more time, IEP meetings are going to be your fastest resolution process. So if you've had all your IEP meetings, you have everything in writing, no one wants to have any more IEP meetings, you're still at a standstill. The next thing you have available to you is facilitated IEP meetings. And so this is when the Illinois State Board of Education provides someone who's trained to assist in effective communication. And with that, this procedural safeguard, this dispute resolution avenue, if you will, is most successful when communication is the problem. So if your meetings, you come to your meetings and emotions get charged and people get mad, and as a parent of a student with a disability who had IEPs, I am very open about the fact that there were meetings I went into for my student that I was caught off guard by something either very positive or very negative, and it made me almost worthless in those meetings because I spent the whole meeting, excuse me, I spent the whole meeting, trying to bite my tongue to not say anything. At that point, communication was the problem. I knew at the moment that it was me. I knew that getting up in someone's face and explaining something to them, or the rude comment that they made, even when it was positive, they say super wonderful things, and I would be like, oh, it's so wonderful to hear. And then I'm not sure, like, you're a little bit on that high of that everything is going well. And so with that, keeping that kind of thing in mind, communication. So your emotions impact your communication. There's all kinds of other things that impact communication. What I see most often is emotions. But when we get to that, and we're in those meetings and we feel like we're not able to properly communicate, that's when I feel like a facilitated IEP meeting is the best way to serve the situation. It's like bringing in a neutral party, but the neutral party is just going to facilitate communication, and that is perfectly fine. They are not going to be decision makers. They are not going to mediate and sort of engage the back and forth. They are just there to help make sure that communication is done clearly, and presented to both sides in that way. So they can be super beneficial if used for that kind of need, in my experience. IDEA, that federal law does not discuss facilitated IEP meetings, but everybody kind of does something different. So what I did was I put the link up here to more information about the facilitated IEP meetings. So if you wanted to make a request for a facilitated IEP meeting or learn more information, that's where you would get more information on that. There isn't a whole lot of law for that. That's a state choice. Excuse me, sorry. Okay. The next thing I want to review as part of your procedural safeguards is state complaints. And I think, and I'm slightly biased because I'm doing them all the time, but I think state complaints in Illinois are more fruitful than they are in other parts of the country. I get together with advocates all over the country and hear about their experiences, and a lot of them don't file state complaints. They feel like it doesn't quite get them where they need to be. I think with the structure that Illinois has set up, where the Illinois State Board of Education oversees the districts, that it works out well, specifically when we're talking about things that are concerns that are procedural. So you're supposed to get your draft documents 3 school days before an IEP meeting. And so if you're not getting those, if you've asked for them, it's continually not happening, and you want the school district, to be trained on that particular law, or you want them to be trained on the policies and procedures, then the best way to do that is through a state complaint. It's a very simple form. They make it easy to do, to complete. You can complete them online. You can download them and complete them that way. Any person or organization can file a state complaint. It just has to be within 1 year of the violation. And so then what happens is you submit the complaint form. All the directions are on the actual form. So the link is right there to that form. The directions walk you through every step of what needs to be completed, what needs to be signed. And then the last step of the directions is that it has to be emailed to the Illinois State Board of Education's complaint email, which is on there, and also your school district superintendent. And so once that is submitted, then the Illinois State Board of Education typically acknowledges it, and they have 60 calendar days to investigate those allegations and provide a report of findings. So that's why when I said originally, that you're going to have a quicker turnaround, you can make change faster using meetings, like using IEP meetings, whether that be facilitated or not, because those can be set up in a much shorter period of time. Once we get to state complaints, 60 calendar days is a long time. We want it to be a long time. We want it to be a good investigation. We want to give parents or complainants time to get in and talk about their situation with the investigator. We want schools to provide documents. There's a lot of back and forth, and then there's a report to write. At the end of the report, when they submit it back, it will have findings. So it will say that this allegation, that this law was violated, is either founded, which means there's enough evidence to support it, or unfounded, which just means there's not enough evidence to support it, with recommendations on what to do next. So that, again, we're talking about procedural things timelines specifically. State complaints tend to be effective in Illinois in getting some of those procedural things changed. We have also seen parents use state complaints as tools to make systemic change within their districts. So we have had school districts that file complaints about the same thing from multiple parents, or multiple parents in one complaint, and sort of acknowledge that this is more of a systemic issue, and they want the board to look at the State Board of Education to look at that way. So they can be very effective for that. Your next safeguard is mediation. So for the next two things, we're going to talk about mediation and due process. I want you to understand what they are and what the difference is. I will say, just in full disclosure, that we know that when a parent is ready for mediation, the law says you can represent yourself as a parent. However, you are over 70% more likely to be successful in mediation in due process if you have attorney representation. So for my program, this is the point where I step back. I've helped families gather and collect. We've got all the prior written notice. We've had all the meetings. We have all the documentation, and we just cannot come to an agreement through an IEP meeting with the school district. So then the next step we might look at would be mediation. So it's a voluntary process. So both the school district and the parent can request mediation, but both parties are able to decline that. So a parent might request mediation and the school say, no, we're not going to do that, which happens sometimes, for sure, where we're like, no, we're not going to do that. We're not going to look at that through mediation. And mediation is exactly what you would imagine a mediation to be. So you've got party A on one side, party B on another side, and you have a representative from each of those parties that come together with a mediator this time. The mediator is appointed by ISB to help find a middle ground, to help everybody meet in the middle. So when a parent or a school district is denying mediation, it's typically because they do not believe that they can come together and find a middle ground. And sometimes that is accurate. Sometimes we've done all the things, we've gone through all the options, we've reviewed it, and mediation can't be helpful. However, we do see a lot of success in mediation where we're able to come to an agreement so that we can put in a legally binding plan in place to go back and try to rectify whatever the concerns are. It can be used for any part of the IEP development when the district and parent disagree. But again, reminding you that this is voluntary. In my experience, this is most effective when both parties understand the issue but cannot agree on the resolution. So when we're looking at facilitated IEP meetings, those are best when we don't feel like we understand the problem, the communication isn't there. Mediation is most successful when everybody understands what the issue is, but we can't come to an agreement on what the resolution should be. And then you'll see at the bottom of this page, there is a link to more information on mediation, how to request a mediation and how to get that started. Again, remembering you are able as a parent to request mediation all on your own. You do not have to have an attorney to do that. And then last, but certainly not least, on your list of procedural safeguards is due process. So this is used to resolve disagreements for anything with FAPE. So in my experience, this is most effective when concerns are substantive and a third-party decision maker is needed. So when we, disagree about the substantial part or the substantive part of the IEP. So we're not going to disagree about maybe eligibility, but we are disagreeing on how to implement services, things like that. A parent or a district in limited circumstances can file due process within 2 years of when you knew or should have known the district violated the student's rights. So when we're looking at due process, it's more of a court visual. So we're talking about witnesses, we're talking about, providing evidence to an administrative hearing officer who is then, hearing all of those things from both sides, and then they are making a decision like a judge would in a courtroom. Due process should take place in 75 days. With that hearing, I will say there are, just like with any other court hearing, that can go on for a long time with continuances and things like that. So that is why it is super helpful to have an attorney who has expertise in due process available to kind of help walk through that process, because it can get very heavy in legal jargon. More information about due process for parents can be found at that link. The directions can be found at that link. I believe that the next couple trainings that are in this series that Family Matters is offering will dive deeper into what those look like with presenters that actually do them. They do state complaints, they do due process, things like that. And so you can get more information by attending those trainings. All right, the next slide is other pieces to be aware of. So other rights you have, things that I want all parents to know. I hope you never need this information, but there are also certain pieces of your procedural safeguards that are very specific to placement disagreement. So remembering that placement in special education is not brick and mortar. We're not talking about the classroom setting where they are receiving their education. Placement is the amount of time that a student is spending in general education versus special education. So when we disagree with the team's decision for a placement change, the parent has 10 calendar days to freeze the previous IEP and placement while you utilize mediation and due process. So there's a lot of working pieces to that. It has to be filed within those 10 days in order to invoke stay put, is what they call it, and go back to that last IEP. You also have the right to access to records. So a school district has 10 days from your request to provide you access to your students' educational records, and it can be extended by 5 days under the School Records Act. We strongly suggest looking up who your district's record keeper is, because under law, each district has to have one, and making the request in writing to them, although the law does not require it. So if you said in a meeting, I want to see all of the speech records, that does suffice under the law. The time starts then, but it's really hard to prove if it's not documented properly. So anytime that happens, shoot another email over and say, hey, in this meeting, I requested this, just want to make sure that the record keeper, CC'd on this email knows that. It gives you a paper trail to make sure things are kind of going where they need to go. So my last slide before we open up for questions is my own creation. I will be very honest. This is the extent of my graph making skills. We have someone on our team who is much, much better than I am at this, but this is a breakdown of what we've talked about throughout this training. So this is how I visualize when a parent comes to me and they say, I have a dispute with the school district. The first thing I'm going to ask them is, have you had an IEP meeting to discuss the concern, and was it documented through prior written notice? If no, I'm going to suggest doing those things. So request an IEP meeting. And again, if you feel that the issue is communication, you may want to consider a facilitated IEP. If you've had the IEP meeting, you've gotten prior written notice, so you're on the left side here, yes, then we want to look at, is a concern procedural or substantive? And so that's what I would talk through with a parent. I would say, is this a procedural violation where they didn't do something? We have documentation to show that something didn't happen the way it was supposed to under procedures, and we can support a parent by helping them file a state complaint. If the complaint is more substantive, so we're disagreeing about how many minutes a student needs or location and placement, then we want to look more at mediation and due process. And you'll notice that you still retain the right to file for due process if mediation is unsuccessful. So if you get to mediation and we're here and it doesn't work out, you still can file due process. So this is my shorthand mental, it's a peek inside my brain as to what I would walk a parent through if they called me about the procedural safeguards or if they were having a disagreement. So I wanted you all to have that thought process. So that is it. We're down to just questions. I think
Okay.
I'll let you.
Absolutely. So just before we move on too much farther, I wanted to explain Family Matters' role in this process. So when a family calls us for support in understanding their role in special education or understanding more about evaluation results or what their child's progress is, we help them work through that to our best of ability. But after we've worked together, if they still feel like they need the support to an advocate, that's where we move on to another entity that can provide them that physical advocacy support. So that might be Laura, IGAC, it might be your local Center for Independent Living or another type of agency that can help with that educational advocacy proponent. Family Matters does not help write state complaints, so we do not go to mediation, we do not go to facilitated IEP meetings, and we do not attend due process hearings. So we're quite similar to Laura in that aspect of things, but we do help you to understand to our best of ability what your role may be in lots of different ways, like it says here, like we did this training together today, or we may review your records, you might watch, attend one of our classes, that type of thing. So more ways to get involved with Family Matters would be possibly being an educational surrogate parent. Not that I'm encouraging you to do that in any way. So we always need more ESPs. To find out more about that program, you can absolutely contact me after this presentation. We have educational events all the time. We're getting ready for a big virtual special education summit. I think that's what we're calling it now. Laura will be there too. You can donate to our program either through a donation. You can pick something off of our wish list from Amazon. You can send us a message and say, I want to make sure a student has such and such. We can do that. You consider applying for a board of directors. And you can absolutely always share information about Family Matters Parent Training and Information Center within your network. Or if you live in the Chicagoland area, you can absolutely share information about FRCD. So FRCD serves 8 counties that surround Cook County, and they serve them. So now we are going to stop the recording, and then we will open it up to questions. So thank you, everyone that listened to our recording today.